Hi, I'm Dan Ehrman, and I am Director of Hybrid and Online Programs at Northeastern University School of Law. And I also run our minor in Law and Public Policy for undergraduates at our School of Public Policy and Urban Affairs. The United States legal system is a pretty complicated system. Number one, we inherited it from the British, who people, of course, in New England will remind you we kicked out in 1776. But we still had to establish a government. What's tricky is that the various states already had operating governments and legal systems. So the Commonwealth of Massachusetts has its own constitution or its own rule book that predates the US Constitution. So when we talk about the US legal system, we are often talking about 51 plus systems because each state has a legal system, and then we have the United States Constitution, which is our national legal system. That can lead to a lot of confusion. The Constitution does try to resolve it by having what is called the Supremacy Clause, and that basically means if there's ever a conflict between a state law and a federal law, the federal law always wins. So the Supremacy Clause resolves those conflicts. However, when most people interact with the law, whether it's a parking ticket or property taxes, they're really interacting with state and local government, not the federal government. That doesn't make the federal government any less important. It just means that the federal government is usually dealing with issues of national scope, and most of us do not interact with our national government on a daily basis. So you'll hear a lot of concepts. One of them is the rule of law. And when you think about the rule of law, it really comes from a quote that is, "We are a nation of laws, not men." I should also note women. But the quote is rule of law, not of man. And that's supposed to mean that the law applies to everyone, and it doesn't matter who you are because you have to abide by the law. Americans were rejecting a system that the British had imposed on them, where basically the laws applied to everyone except the crown, except for the king. So in the 1990s, there was a lawsuit against then President Bill Clinton. And there was a lawsuit that he didn't want to have to basically answer or be involved in until he was no longer president. He wanted to be immune from the lawsuit. And it made its way up to the Supreme Court. And the Supreme Court's opening lines were basically, this case involves a lawsuit against a person who happens to be president of the United States. President Clinton's lawyer said when he heard that, he knew it was not going well. And as the lawyer predicted, President Clinton did have to comply with the court proceedings. The overall point there is that even the president is subject to the nation's laws. One way that we can ensure the rule of law in America is that our federal judges are appointed for life. The actual wording is during good behavior. But the idea there is that federal judges will not worry about whether they have to face elections, whether people will try to, quote unquote, throw them out of office. And that ensures judicial independence, that they can make the hard decisions that are not always the popular decisions.